Good morning and welcome to Legally Raven here. This morning we're going to do a very quick video because we literally have 9 minutes. So I'm just going to share my screen. Today we are going to talk about removal. I think, here we go. Yes, we're going to talk about removal. What is removal? So civil procedure, removal deals with federal subject matter jurisdiction. So removal is under the U.S. Code section 1441A of Title 28, and it says any civil action brought in a state court of which the District Court of the United States have original jurisdiction under 29 United States Code section 1331 may be removed by the defendant, unquote, to federal court. So under section 1331, a federal court has original jurisdiction over federal questions. And then 1332 helps us to see that they have jurisdiction when there's concurrent, when there is a diversity in between the plaintiff and all the defendants. So concurrent jurisdiction, Article 3, Section 2 of the Constitution also authorizes federal courts to hear cases between states, cases to which the United States is a party, and then admiralty and maritime cases and others. The fact that a case can be heard in federal court does not mean that it must be. So most cases that are within federal court subject matter jurisdiction may also be heard at state court as well. So now we have an example here of Callahan from California. For example, if Callahan from California wants to sue Coletti from Oregon for $200,000 for breach of contract, she may bring the case in federal court, but she can sue in state court if she prefers. So this is concurrent jurisdiction. Both the state and federal government have jurisdiction in diversity cases. So since the inception of the federal courts, federal removal statutes have authorized defendants sued in state court to remove certain cases to federal court. What's the rationale? Well, this rationale is so that the defendant is not subject to the plaintiff's home court advantage by suing in their home state. So the defendant has the same right to hear a case within federal subject matter jurisdiction as the plaintiff has, so to make it fair. But this is a one-way street. If a plaintiff chooses federal court, the defendant cannot remove to state court. So this allows you to move from state to federal, but not from federal to state. All right, so let's talk for a little bit about, so once again, it's the Title 28 of the U.S. Code, Section 1441, removal of civil actions again. So otherwise expressly provided by an act of Congress, so except as otherwise expressly provided by an act of Congress, any civil action brought in state court of which the district courts of the United States have original jurisdiction may be removed by the defendant or defendants. They all have to agree, which is something else, to the district court of the United States for the district and division embracing the place where such action is pending. So one of the things that says is that if there's diversity of citizenship and you decide that you want to move a case, you can't say, oh, well, if the case was filed in Texas, I have the right to move it to the federal court in the district that state court sits in. I can't say, oh, I want federal court in California. That's not allowed. Now, one question I have here, what are some ways that are expressly provided by Congress? I have to look that up. So original jurisdiction, a plaintiff can remove a case of which the district courts of the U.S. have original jurisdiction. That means the plaintiff could have filed in federal court initially. So one of the things here that we have is that Avitts v. Amoco production company case. And so we see that here, there were some landowners that got together as plaintiffs and they sued Amoco production company and maybe a few other defendants, I can't remember, but basically it said, you ruined our land. And they had many state law claims such as nuisance, trespass, negligence, breach of contract, the entry of the property is in violation of not only state law, but also federal law. So they just did this brief mention of federal law. Well, Amoco decides to remove the case from state court and file it in federal court. Right, so the district court ruled for the plaintiffs ordering Amoco and the other defendants to pay for an environmental study and interim attorney fees. So the thing is that really there was no subject matter jurisdiction here. The plaintiffs cursory mentioned, some federal law. And then I think later maybe they did an amended complaint, to add in a little bit of federal law. But then Amoco came back and was like, hey, they didn't have subject matter jurisdiction in the first place. But Amoco was the one who wanted it to be in federal court in the first place. They could have left it in state court. So how did this end? I'll have to follow up on another video about Amoco. I just really wasn't sure in the end, to be honest with you. Oh, in the end, it says, when did Avitts, the plaintiff, move to remand the case to state court? The opinion contains no indication that Avitts ever moved to remand, and a later opinion in this case explains that Avitts did not. Avitts amended the complaint after removal, and the amended complaint omitted any reference to federal law. Yet the federal district court retained jurisdiction, held a hearing, and entered a preliminary injunction requiring Amoco to conduct an environmental study and to pay very hefty interim costs. Things seem to be going well for Avitts in federal court, even though he and the co-plaintiffs didn't choose it. Why look a gift horse in the mouth? Conversely, things did not look so good for the defendants, now subject to a burdensome order from the federal court. So just before the trial, the defendants who had removed to federal court moved to remand for lack of subject matter jurisdiction, and Avitts opposed the motion to remand. After the pretrial conference, all the defendants moved to dismiss the action on grounds that the district court had no federal jurisdiction or diversity jurisdiction over any part of the action. Appellees, the plaintiffs, opposed the motion, arguing that the district court had authority to entertain the action under its pendant jurisdiction. I need to look that up. I don't know what that means. I think it means the fact that the case is already there, but I need to see. Appellees, for the plaintiffs, persuaded the district court to deny the motion to dismiss and retain the case in federal court. In fact, the district court embraced the appellee's position and characterized the defendant's jurisdictional argument as meritless. Okay, the appellate court's conclusion. The Court of Appeals concludes that the Avitts complaint only asserted state law claims, so it was improperly removed. Although the complaint included several general references to federal law, Avitts did not sue under any federal statute, nor was there diversity between the parties. Thus, the case could not have been filed originally in federal court and could not be removed under Title 28 of the United States Code 1441A. There are echoes of the Motley case here. So the defendants did an interlocutory appeal. Generally, parties in federal cases may only appeal from final decisions of the district court. That is when the case has been fully decided in district court. But U.S.C. 1291, Court of Appeals have jurisdiction over appeals from all final decisions of the federal courts. That way, all the parties' objections to the trial court's rulings in the case will be resolved in one appeal, if there is one. Thus, the federal district court's decision and the federal court had jurisdiction would not ordinarily be appealable until after the case went to final judgment. However, 28 U.S.C. 1292A1 provides an exception to this general rule. It allows interlocutory appeals and immediate appeal, even though the case is still pending in trial court. All right, so what happened to the order for the environmental study? When removed cases, as well as cases filed initially in federal court, if the court lacks jurisdiction, it cannot proceed. So ultimately, this case was remanded and sent back to, it was vacated and remanded, and it was sent back to state court. So here we have original jurisdiction. Federal question, it either has to be a federal question. The plaintiff is the master of the complaint. So the complainant decides if it's removable. You can write the complaint in such a way that it is not removable. And then we have here, you have 30 days if there's a lack of subject matter jurisdiction to try to get it remanded. The other way is that if there's diversity, so if there's a ton of defendants, if even one defendant lives in the same state as the plaintiff, then you don't have diversity jurisdiction. So that is removal in 9 minutes. Bye.